It's the appointed time and we have a quorum. I call the meeting to order. I can't hear you. We have it. Yes, this morning is the English version, and just now is the Chinese version. Welcome government officials. We have with us the Principal Assistant Secretary Ms. Carrie Chang from the FSTB, Ms. Renita Au, Assistant Secretary from the Department of Justice, Senior Government Counsel Ms. Carmen Chan, Government Counsel Ms. Annette Lai, from the SFC, Director Investment Products Ms. Grace Chan, Senior Manager Ms. Fiona Zhe, Manager Ms. Chloe Wong, and Consultant Ms. Mary Ahan, and from the Company's Registry, Consultant Company Law Mrs. Carrie Ho, Deputy Registry Manager Registration Ms. Angelina Mock, from Officials Receiver's Office, Chief Treasury Accountant Mr. Jason Chu, and Assistant Principal Solicitor Mr. Alvin Sin. This is the second meeting. First of all, I would like to follow up with you something after the last meeting on the 8th of June. The administration has given us a written reply in response to issues raised from the last meeting. Is paper number CB bracket 11102/17 to 18 bracket 02. This morning you have already been given the English version, and I think about an hour ago you have received the Chinese version. Mr. To said he doesn't have it. Oh, he has it now. Perhaps we can ask the administration to take us through the response paper. Thank you. I'll defer to the SFC. Six points raised in the last meeting has been covered by this document. First is in relation to investment manager of OFCs, whether there are additional requirements. We have already answered that if it is just the investment manager of an OFC, the responsibilities is actually the same as other SFC authorized OFCs and investment funds. They have to abide by the codes and also the product handbook. Since it is as investment manager of an OFC, the manager will also have to conform the OFC code and requirements. These requirements are actually similar to those set out in the SFC product handbooks, that is, in relation to the instrument of incorporation as well as the investment agreement. The investment manager will have to follow those requirements and work in the best interest of the company as well as its shareholders. An OFC investment manager is also a regulated activity 9 licensee, that is type 9 regulated activity licensee. So the investment manager is subject to the same regulatory requirements applicable to this type of regulated activity. The second point is in relation to winding up and how it's different from a conventional company. Under the OFC rule, the voluntary winding up procedure is simply copy and pasted from the company's winding up and miscellaneous provision ordinance. that includes the reasons for starting the voluntary winding up. The key differences are three set out as set out in the paper. First, the SFC can be added as a party in relation to any court ruling. And if the wound-up company is going to call a general meeting, then the SFC will be notified because it is the OFC's principal regulator. Under the OFC structure, there will be the additional positions of custodian as well as investment manager. So, the investment manager and the custodian of an OFC will be added to the list of persons. Under Cap 32, if a party has potential conflict of interest, then that person cannot become the company's provisional liquidator or liquidator. So we will add to the list of persons investment manager and custodian. A declaration or statement will have to be made. Well, in relation to winding up of sub-funds, we have also added this. In relation to court winding up, well, under Cap 32, an OFC is an unregistered company. So when it comes to court winding up procedure, it will follow the procedure of non-registered company under Cap 32. Compared with conventional companies, the major difference is that if it is an unregistered company, the reasons for the winding up is narrower, and we have already set out those reasons in the paper. The third point, perhaps we will wait for the paper to be presented before questions are asked. Sorry, I just want to ask about the reasons. Which paragraph are you talking about? I'm just reading the paper. I will have to follow as closely as possible as the presenter, otherwise I'll get lost. It's not ideal. I have technical questions to ask, and you only give me this paper today, and I have been engaged with other technical meetings related to the SFC. I have no time to read it at all. Well, the last meeting was last Friday. I'm aware of that. I just ask for a bit of indulgence from the company. Yes, I have all the patience in the world. I just suggested that perhaps we will let the SFC go through the paper first, but I can't even follow. And then I had to rush to a later part. Maybe it's because I'm a slow learner, but I don't think so anyway. Well, I thank member for the question. You will find in paragraph 9 the grounds for winding up by the court, A, B, and C. If it is just a conventional company, apart from those grounds set out under paragraph 9, there can be reasons under paragraph 10, namely A to D, for a court winding up. In paragraph 11, if a conventional company breaches requirements such as record keeping, the registrar may also petition for court winding up. So we have set out the major differences in paragraphs 10 and 11. Perhaps you continue? Next is in relation to the circumstances and whether the SFC has powers to override the OFC board's decisions or seek remedies. Under Section 214A of the SFO, if the SFC is of the view that a certain SFC, the business has been conducted in this manner after the incorporation, namely A to D, then a court order may be petitioned for. A is oppressive to shareholders or any part of its shareholders. B is in relation to defalcation, fraud, misfeasance, misconduct. C is in relation to not giving all the information reasonably expected by shareholders. D is unfair prejudice. On application by the SFC, the court may make various orders. Say, for example, an order restraining the carrying out of an act or other orders. Say, for example, alteration of the instrument of incorporation. 214A was newly added in our exercise in 2014. It models after Section 214 of the SFO. Well, what do we mean by unfair prejudice? It may be the case of persons that has conducted itself in fraudulent action. And paragraph 14, it says out the power where the SFC can make an application under Section 213. Say, for example, certain mandatory provisions of an instrument of incorporation is inconsistent with the resolution passed by the board. Say, for example, in 2016, when we amended the principal legislation to introduce the OFC structure, there is Section 112K. It says that there are certain mandatory provisions in an instrument of incorporation. If these terms is inconsistent with the instrument of corporation, or if the OFC acts in a manner that contravenes such mandatory provision, the SFC may apply to the court for a restraint order. We may also impose registration condition on the SFC by requiring that in its offering documents there should be an update with reference to the terms of the court order granted under 213 or 214A. Say, for example, to remove disclosures that are found to be unfairly prejudicial or in contravention of the statutory or regulatory requirements.
I'd like to talk about the issue raised by members earlier, that is the circumstances under which we would accept the to propose a compulsory redemption of the OFC shares. The investment fund, I think the offer documents of an investment fund may provide for certain specific circumstances in which a compulsory redemption may be made. Such circumstances would typically include where an investor would be in breach of the relevant laws and regulations by holding interest in the fund, or the holding of such interest by the investor may result in adverse tax consequences on the fund as well as other investors, in which case the OFC has the power to have a compulsory redemption. In considering the acceptability of a constitutive or offering document of an OFC which provides for compulsory redemption in some circumstances, we would consider whether such provisions may contravene the applicable legal and regulatory requirements, including whether or not it constitutes a case of unfair prejudice to shareholders under Section 214A. Next, starting from paragraph 23, which is another a question raised by members at the last meeting, and our response in paragraph 23 is in respect of the registration of privately offered OFCs. The question was why private OFCs needed to be registered, and whether or not so actually the OFC regime and regulatory framework had in our public consultation in 2014 and 2017 received general support. The legal and regulatory requirements in the OFC regime are intended to lay down the same basic or minimum operation requirements applicable to the OFCs, and also with reference to the international practice. So our approach in imposing certain essential regulatory requirements to privately offered OFCs is broadly in line with the approach in other jurisdictions such as the UK, Ireland, and Luxembourg. We understand that the members asked at the last meeting that these privately offered OFCs, whether the for these private OFCs, if they satisfy the basic requirements in our code, then matters in respect of the operation of these private OFCs will remain largely governed by their own, constitutive and offering documents, and also their investment strategies, dealing intervals and fees, and so on. And also, a more streamlined approach also applies with regard to the approval matters of privately offered OFCs. For example, the offering documents and scheme changes of these privately offered OFCs will not require our prior approval. On the other hand, publicly offered OFCs, since they are sold to the public, then other than complying with the OFC rules, they would also be required to be subject to the more extensive requirements under the Unit Trust Code. Furthermore, the filing requirements of the OFCs with the company registry are for basic corporate transparency purpose in view of the limited liability nature. Such filing requirements are actually in line with those existing requirements for private conventional companies under the company's ordinance, but are streamlined for the purpose of the OFC. For example, these OFCs would not have to file notice of alteration of share capital, return of allotment, return of share redemption or buyback, and annual return. Where a private fund opts for the OFC structure instead of a unit trust structure, then while it would be subject to the registration process and the basic requirements as set out in the OFC related laws and regulations, it would also be able to benefit from the profit tax exemption provided by the Inland Revenue Amendments No. 2 Ordinance 2018. Furthermore, as a corporate fund structure, it is generally popular internationally, so offering a private OFC structures would provide an additional choice for the fund industry in Hong Kong. In considering the regulatory framework for privately offered OFCs, we have actually made reference of the approach in international other jurisdictions and also the fundamental principles of IOSCO. Thank you for that. I understand that this is a very detailed response to the questions raised by members at the last meeting. And now let me ask whether members have any questions in relation to this paper. James Toh? Perhaps I'll start from the end. Chairman, I'll start with from paragraph 23. I'm not saying that I'm starting with the more important issues first. Well, one of the SFC's answer is that now we're talking about the identity of the OFC. I believe that in order to ensure there's no fraud, the company will need to have its directors, registered address, and a share capital. So what? Now, registering with the common registry is one thing, but for the OFC code, which is privately offered, we're talking about the activity of the fund. Now, let's say the company registry requires certain information. After I've become incorporated, I can sell peanuts or fashion or whatever. I don't need any further registration. And now, if the company, you have several people coming together to make investment, then the company will have to furnish further information. So, and I would object to this. Is it your answer? I mean, I've read all your points, but for paragraph 23, 24, and 25, do you only provide for such information with the company registry, but do you have other activities? Let's say for the company providing currency exchanges, they are subject to other regulations. Let's say several people come together to make investments. They set up the OFC. What are the extra information they need to submit, and why? Thank you. I think to register as an OFC, I think we are providing a one-stop service. So the applicant will need to come to the SFC, supply with all the documents, and if we are satisfied that they qualify, we will issue them with a certificate of registration. If we think that it's okay, that we will refer the documents to the company registry. After the company registry has gone through the documents and is satisfied, then they will issue a registration, certificate. So the registration of the OFC with the FCC will also become valid at the same time. So if you want to set up a private OFC, now let me put it this way. Compare with a non-conventional company, of course they will need to register with the company's registry. But you now have additional requirements other than those conventional companies. What are the extra requirements? As far as I'm concerned, if the requirements are the same as those applicable to other conventional companies, I won't object, because those conventional companies need to come to you. The OFC will need to apply to the SFC. The question is, why do the OFC have to furnish more information to you? Thank you. I think if they want to set up an OFC, they will need to satisfy our rules, the SFO, and our code. For a conventional company, they don't need to hire an investment manager or a custodian. So these are the extra requirements. Exactly. I understand that. That's why I object. If they have a smaller number of members and they don't make it a public offer, so all you enact a piece of legislation to oversee everything they do. I don't think it's necessary. I think the basic principle of enacting legislation, well, I think she's answered your question, but you don't agree. I think the fact that we have a dialogue, I think we need to explain to members, I mean, you can't just tell us that we need this information, hence the requirement. Now, recently, the company registry said that these company offering secretarial services also need to, comply with certain requirements. For example, the company registry may require information in order to combat, money laundering. Then I agree. But what exactly is your motive here? Let me first ask whether other members want to ask questions. Otherwise, Mr. Toh may continue. Mr. Toh said, say, if several people come together to form an OFC, why do you have these extra requirements? And you also even mandate that they should appoint an investment manager, and the investment manager would need to be accredited by yourself, by the SFC, and now I have to appoint a professional to do that. Why such standards? So why such extra requirements? Mr. Toh, if they don't, choose the OFC structure, they can form a unit trust to make the investment. If he doesn't want to hire an investment manager or custodian, if he doesn't use the OFC structure, then, and if he doesn't make a public offer, they will not be subject to regulation. No, you've not answered my question. Why do you have this OFC structure which you need to supervise? How does that interface with your policy objective? I think this is basically for investor protection. If you look at the supervision in other jurisdictions like the UK and Ireland, even for OFCs, private OFCs, they're also subject to regulation. Well, in that case, you talk about unit trusts. They're also being sold in the market. Let's say the few of us form a unit trust. Why is it that you don't have such requirements for unit trusts? I don't understand. Let's say the 6 of us form a unit trust. You say you don't need to comply with the requirements. I think the answer just now is that if you if you set up a traditional fund, then you don't need to comply with these extra requirements unless you adopt a new format. And the SFC have actually made reference of the experience in other jurisdictions, and that is consistent with those practices. I think that's the answer.
This is not an intellectual answer. You said you have drawn reference from overseas practice, and you can't say that, well, if they do it this way, we will do it the same way. But let me finish first. If you say that it's about tax, well, then if I want to get some information related to tax matters, well, then yes, you can do that because I offer you tax concessions, but it is not related to tax, and it's not a request made by the Inland Revenue Department. Well, the relevance will have to be direct and proportional. I do think that Mr. To is not happy with the explanation because it fails to convince him. Do you have any further reply to give to Mr. To? I don't think this is a platform for the member, for the director to be convinced, for the director to convince the member. Of course, I will. You can ask for the information. But if the director has already given the information and the member remains unconvinced, we can only just continue. It doesn't matter because the public will be watching. I ask you to go back to think again. You want to regulate something, but you can't give an answer. I think it is a failure on the part of the government. It may not be the SFC, it's the who? The PAS from the FSTB. When you legislate, you have to convince the public why you're doing it. So go back to think of a better answer. If you say, I won't, well, that's well and good. Director, if you have further information to supply, then please do so in the next meeting. Sorry, I was thinking. Perhaps the SFC will supplement. We thank the member for the question. We do understand. You may think, well, if it is a small scale and we all know each other, why do you impose the extra constraint on us? I think that's the core of the issue. We try to strike a balance. Back in 2014, the FSTB consulted the overall structure of the OFC as well as the regulation of private and public OFC. There was a public consultation. We have looked at the comments and replies before we work out the framework. Most of the respondents in the consultation agree with this model. That's why we work from there. Since most of the comments we have received in the consultation support the framework, so we proceeded based on that. When the principal legislation was enacted, well, it touched on publicly offered OFCs as well as privately offered ones. Information was supplied to enable discussion on the framework. The requirement under the principal legislation is that an OFC, whether it is public or privately offered, will have to be registered with the SFC. There is this requirement in the principal legislation. What we're trying to do are the rules, which is to put in detail the actual requirements set out in the principal legislation. Well, this is for your information to give you a complete picture. I would like to reply to this point. Well, you talk about consultation, it was mentioned. You should have said in the consultation why you propose to regulate this and that. Say, for example, OFC, non-open-ended, privately offered, publicly offered, instead of saying that, well, this is our proposal without giving any explanations. And then you say, since no one opposed to it, it means that they have accepted that you want to regulate. Well, take it to the highest. You say you're not afraid of being held responsible. You say that well, in the public consultation, no one voiced any objection. Well, now I ask you. You can't say that since no one opposed to it, we will continue because it's fait accompli. Sorry, I won't be restricted by that fact. You may say, well, you were involved in the scrutiny. Then I was wrong. What I'm trying to do is to ask you to explain to me why you want to do something. Perhaps I will stop you from legislating for this subsidiary legislation so that you will have to start again. No matter at which stage I ask you, you should be able to answer the question, to tell us what is the basis for the proposed regulation. Well, in relation to this point, if you have further information to supply, please do so in the next meeting. We can move on to the next point, Mr. To. I will go from the back. Now is paragraph 18. Just a general comment. Paragraphs 1 to 27. I do think that it is quite good that they can come up with this paper within such a short time. It's not in great detail, but at least they have tried to reply to the points raised. It's not like some people who are trying to dodge left, right, and center. So I can see that you are sincere when it comes to trying to answer our question. Paragraph 18. Oh, just let me get some confirmation. Paragraph 18. Apart from the questions that one can ask, the registrar has no other power of investigation. Say, for example, if false information is supplied, well, I have other power of investigation or inquiry. And now you say that, no, that is the only way to find the information. Is it really the case? I doubt it. I wonder if you have read through the company's ordinance or this one, or this piece of legislation. Or is it the case that you have decided not to copy and paste some other powers in the CO and you've only kept the power of inquiry? I'll defer to the company's registry. Mrs. Ho. Section 14, Rule 49 of the rule is in relation to sections 865 and 876 of the company's ordinance. The intent of having this rule is that is to strike a balance between the exercise of the registrar's power of inquiry and the right of the person who is the subject of the inquiry. As you said that if the registrar has to investigate into a false statement, this power has to be relied upon because there is no other power to conduct the investigation. And it is only in relation to false information in documents provided to the registrar. We have, this has mirrored other sections in the Kunwing Yi versus Securities and Futures Commission. You will find relevant information. Sorry, I have to interrupt. Well, yes, the registrar asks for documents, say, for example, an address of the director, and A is filled in. And your answer is that if I suspect that it is false, then I ask you, is A correct? Well, now you say in public that this is the only power you have. So the subject of the inquiry will say, yes, it's true. Well, you can ask other people, you can go to the address. And you say, well, I can only ask that person whether A is true. And if that person says A is true, then there's nothing else I can do. I don't think so. But The information contained in documents, information in registrar, information supplied by other persons, and whether there are other people that we can ask the information from. So it's not just that, well, we only ask the question of that person and leave it at that. But in paragraph 18, you said there is no other power of investigation. Yes, we can ask that the subject for information and ask for further information. Of course, if there are other people that we can get the information, we will conduct the investigation in a similar way. If you ask the person of a question, well, the person has already filed that address and you ask the person to answer. Then you can charge him with 2 offenses. One is, providing false information under Rule 49. And the second charge is the false document. You don't have additional power. I really find it strange that you answer this way. Well, under this rule, the registrar may require a person to provide an explanation and to provide information, provide documents. We can then ask for further explanation. Well, let me give you an example. Say, an address. Can you ask the caretaker of the building that person lives there? Have you seen him going in and out? If you can't, it would be strange that you can only ask questions from the subject of the inquiry. And now you have created something about self-incrimination. It's not a matter of balance. It's whether it is feasible and whether it is effective. Any further reply? Well, the registrar will have to have grounds to believe before he exercises that power. He or she exercises that power. Under A73(2), the registrar has to have reasons to believe that something is done, that an act is committed that is in breach of the legislation. But does it include, say for example, that the address is false? Can you ask, say for example, the neighbors or someone living in the next block? Section 873(2) also says that that the person will have to be in possession of the document or the file. I don't understand why there is this thing, legal advisor. Let me see if I can help. Well, 46. That is a different one. It says require a person. My understanding is that it's not necessarily the person that you've suspected of providing false information. Say for example, A submitted a form, you suspect that the form is false, and if B has relevant information, you have the power to do so because it only says a person.
I thank the legal advisor for that suggestion. That might be so, but I think that answer has to come from the government. If the government said that is not so, then it's rather strange. I think they need to go back and think about this. Company registry, I agree with the legal advisor. That is, the person does not just refer only to the person who filed the document, but it should include. Now, if we have reason, well, people, any connected persons, I think we can make inquiry. We have the right to make inquiries with such connected persons. Next, I'd like to go to paragraph 20. This is the advice you obtain from the DFJ. There is this case law, and that there might not be a breach here. Now, in your drafting, let's say you ask the neighbor or another person, and you just expect the person to make a false statement. Is it that the answer he provided cannot be, produced as evidence in court, whether the filing was false? Mr. To. Actually, the information he furnishes or the document he submits can only be used in respect of our investigation of his offense of making a false statement or perjury. Let me put it more directly. I think we seem to be on a different wavelength. Let's say I live in Unit 1A. That's what I, submitted. I'm the person who submitted information. Do you have the power to ask whether 1A is my address? I say, sorry, I'm not going to answer the question. And if I say, no, actually, I don't live there. If my answer is that, could you say, if I say it's not really my address, would that take away my legal privilege? Yes, for the relevant offense in respect of making a false statement. So in that case, it's related to self-incrimination. But according to the legal advice we have obtained, and we've studied many case laws, that is, when we exercise such powers in the course of investigation, there is no such powers. When there is a criminal prosecution, only then will that person has the immunity, from self-incrimination. But there is no such power in the investigation. Just imagine, even the police would need to make a caution statement. I may not agree with your interpretation. If you look at Section 49, bracket 2, it says, if you force the person to provide the information or an explanation, then such, evidence cannot be used in a criminal proceeding for self-determination, except for what is stated in 48.8 and 6.5, or Section 5 of the Crimes Ordinance. One should not make a false statement. So you're talking about 195, but you said just now that 195 would also apply. I think the government should really clarify everything before they answer the question. But Section 49.2 doesn't, refer back to 195. Chairman, allow her some time. My reading is similar to that of the legal advisor. Let's say if I found my address to be 1 floor 1A and you ask me whether I live there, I said no. And then you invoke your power. So there's no perjury in this case, because the one that I originally filed was false. And you now realize I only live in 1B and not 1A. Now that you know the truth, but you cannot use the answer I give you as the basis to prosecute me saying that I filed the wrong address 1A. Mr. To, is this hypothetical example really true? Section 49, bracket 2 says that we can only prosecute a person pursuant to 48.456. 48.4 said that the person makes a false statement in such documents. And this is what we want to prosecute him for. Legal advisor, could you take a look as well? 46. 48.456. I think the chronology is like that. Someone submits files a document on day one, you think that it's in breach of 159. Only then you invoke, Division 7 and trigger the investigation. Then according to Section 46, you're asking for the information. Section 48 said, according to 46, you submitted false information. So if 49, my reading of 49 is that, according to 49 bracket 2, you cannot invoke 195. You can tell a lie the second time, but not the first time. Well, I agree with the legal advisor. So that's the ultimate answer, right? That it only applies to the second scenario, not the first one. If I ask you a question pursuant to 46 and you lie, you can't invoke the same power under 195. Now, I suggest that we need to be safe. Could the government tell us what is its position in writing? Because if that's the case, to some extent, you have not sacrificed the principle that no one should be subject to self incrimination. Well, a few days ago, just now, the CE announced that we're going to set up a committee to investigate into the MTRC. Now, if anyone should give an answer that would make any statement that the statement should not be used against him in any criminal proceedings, this applies to investigation by Legis as well. So in your answer, you've not compromised the protection against self-incrimination. Perhaps, Director, you can give us a written, a further written clarification. Next, paragraph 16 and 17. I have two questions here. First of all, you say there is a constituent document. So my question is, well, actually there are two stages, time of incorporation and the time when you exercise your power. In paragraph 17, you say you consider whether you consider acceptability of the document. The applicant is applying for registration. Let's say if it's more than 10 billion, then the board or someone or the founder can say that I will require you to redeem 50% of the shares because if it's too much, I cannot make a good investment. But wait, this is the time of registration. The investments have not yet begun. So I don't doubt that if the constitutive document is unfair, of course you will not accept it. But now that you've accepted, if you have accepted the document, when the fund size reaches 10 billion, do you still have the power to further override it? Thank you. When we vet these documents, actually, when they fill in the forms, they will tell us whether they are in compliance with the rules. The so-called mandatory redemption, it does happen, but it's not like what you said, that when the fund size reaches a certain level, then there will be a 50% redemption. But instead, if the person continues to hold such shares, it will have an adverse impact on the fund or the investors of the fund. For example, in the U.S., Now, if you fail to do certain thing and you continue to hold certain funds, it will have an adverse impact on the fund. In that scenario, we don't have OFC yet, but the instrument of incorporation and constitutive document, if they provide for these redemption mechanism, we would allow them so long as it is stipulated in documents. That's not my question. Are you saying that suppose if the fund size is exceeded, then you have the right to ask demand for a redemption? Then I think in this case you shouldn't even approve it. For the public funds, we have our product code. We have other principles requiring the product to be fairly designed. If there are indeed such terms, we would look at them to see whether they are in breach of the rules governing redemption. We'll check whether that mechanism would unfairly prejudice the other investors, but they would draft all these provisions before the members subscribe to the fund. At the vetting stage, there are certain guidelines in the code, and they will approve the fund according to those codes. I'm just testing whether your codes are unacceptable, or that you don't have the flexibility. Under what circumstances we say it's not fair? If the fund manager thinks that the fund size has reached a certain level and then he can no longer make any good investments, generating a good return. Normally, when the fund size reaches that size, they would stop the issuance of new shares instead of saying that they would require the funds to be redeemed once it reaches a certain size. We have rarely seen in the documents of such funds that would require a 50% redemption. They would resort to other methods. Well, that is based on your practical experience, but theoretically, I don't see how it is unfair. When the SFC approves such funds, we're asking whether or not the code is fair or not. I think that are we digressing? I think we should focus on whether or not the provisions are fair or not. Now, if you identify any issues when we scrutinize any bill, only in the course of the answering question will we be able to detect issues. Having heard their answers, I'm really surprised. So I won't pursue this anymore now. Now, my question is that when you consider the registration of the OFC, let's say the fund is still registered. When exercising the power of registration, do you have the further power to override it? At the time of registration, everybody agreed to something, and then you have imposed further restrictions on the fund, and that may not be so desirable. 你知唔知佢講乜？我真係唔知喎。
去到某一日嘅時候，會是否有呢？
Well, so will there be a day when the SFC has power to overturn something that was previously agreed? I think it's back to the answer. That is, whether we have power to override or overturn any resolutions or terms in the instrument of incorporation. Is under 214A, if there is any fraudulent act, any oppressive acts, then we use those grounds to proceed. And it's not us to exercise any power. It just gives us the power to make an application to the court for the court to make an order, an appropriate order. I think it's the best answer. I won't pursue. Well, paragraph 12. I only have one thing to ask. Seems that you have been talking about the SFC's power to override the OFC board's decision. If there is an AGM, and the resolution is unanimously supported, do you still have that power to override that decision? Of course, it's a very stupid question, because if it is unanimous, no one will be complaining, and if you have the power to override it, it will be trouble. Say, for example, well, under SFO, there are some mandatory provisions in the instrument of incorporation. Say, for example, the assets will have to be kept by the custodian. If they pass a resolution to remove that, then it is a breach of the law, and we can apply to the court for an order. Well, in order to clarify, is it the case that well, you can override not just the board's decision, but also the majority decision of the board, right? Yes, of the AGM. Yes. I want to ask about paragraphs 9 and 10. Unregistered company and conventional company, what's the difference? What does it say in the English version? I ask about the major differences. Who is to take the question?
May I answer this one? In Part 10, Section 326 of Cap 32, the definition of unregistered company specifically excludes a conventional company. Therefore, the conventional company will be wound up under Part 5. We've already pointed out in the paper the only difference is really that there are slightly more grounds under Part 5 of Cap 32 which apply to the court winding up of a conventional company. So for the winding up of an unregistered company, this can only be done by way of court winding up. I'm sorry, I've just been alerted to the fact that the question was actually what is an unregistered company as opposed to a conventional company. So the definition of unregistered company includes company type vehicles, including a partnership or an association, but there are certain exceptions, and the main exception is a normal conventional company formed under the Companies Ordinance, and a limited partnership, and a partnership or association with less than 8 members. So our legal advice is that an OFC will fall within the definition of an unregistered company.
If it is an OFC, should it be a certain types of identity of companies before it can become an OFC? Director. OFC is a company incorporated under the SFO instead of the CO. So it's not a registered company under Cap 32. Oh, I see. So it's a different thing, yes. So it's different from a conventional company. That's why you will have to register. They will have to register with the SFC. So this special type of company, in the winding up process, well, you have said that the SFC will be added as a party. They have to be notified because they are heavily related to the OFC. Okay, now I understand. Any other questions from other members? Legal advisor. In relation to unregistered company winding up procedure, under Section 3261B, these companies will have to have more than 8 members. If there are less than 8, then what happens? Who is to take the question? PAS? In the last meeting, we have explained if there are less than 8 shareholders in an OFC, then they have to use Part 11, voluntary winding up of the OFC rules, or the OFC code, the termination process. Procedure, because after the amendment, when we go to the subsidiary legislation, there are some problems with the enabling provision. That's why we can't fully introduce the court winding up procedure. We will go back to the principal legislation. We aim to introduce the winding up procedure under Cap 32 to OFC. It was explained last time. Mr. Toh, I don't understand. Paragraph 15. Well, it says that it is to remove a disclosure. How do you remove a disclosure?
Exactly.
What do you mean? At the time of registration, we may impose registration condition. Afterwards, we can alter these conditions. If we see that under Section 213 or 214A, we have obtained a court order, say for example, the court has ruled that a certain act of the company or a resolution poses unfair prejudice. However, the resolution or the act that has the unfair prejudice has already been disclosed in the offering document. We may impose a registration condition to require the company to remove such disclosure because they can't do it. And if it's already written that this act will be committed in the offering document, we can require them to remove that. Well, how does it work? Because it's a previously registered document. You mean delete it from the website or what? Director. It may be there in the offering document at the outset that there is this unfair or prejudicial act. Well, if it's a privately offered fund, they are just filed. They don't require our approval. If a court order has been made, that means they will have to remove that disclosure in the offering document. So they have to change the offering document. So when the offering document is issued to other people afterwards, that disclosure will have to be removed from that. So if there is new issuance, it will be issued without this piece of information. If the court makes a decision today and tomorrow there is a public offer, it will be made without this condition. But what about those that are sold previously? I think that the court will be aware of the fact that there has been shares sold with this unfair prejudice to the public, and that would also be redressed or addressed by the court in that hearing. While I am otherwise engaged, I would like to just say one more thing. Perhaps let me read through the information next time. I don't have any other points to make. If there are no other questions related to policy, we will go into clause by clause. We can start with either the English or the Chinese, or do it at the same time. I suggest that we will do it at the same time. Any views? If not, we will go into the clause by clause. There are 3 pieces of subsidiary legislation. Let's deal with the first one. That is in relation to Securities and Futures Amendment Ordinance 2016 Commencement Notice. This specifies the commencement date of the SF Amendment O, which is the 30th of July 2018. And in relation to the OFC rules as well as the fees rules, they will come into operation on the same day. That means on that day, the OFC structure will start to operate in Hong Kong. Any other questions? If not, then it's the second one, Securities and Futures Open-Ended Fund Companies Rules, PAS. Thank you. The rules aim at providing for the provisions of the regulation of OFCs. It covers the composition, key operators, and winding up. There are 12 sections, 196 provisions, and are scheduled. Part 1, that is Rules 1 and 2 from page 3028 and 3032. It sets out the definition as well. Commencement date is the same as the commencement notice, that is the 30th of July. Any questions? If not, please continue. Then is part 2. Part 2 is in relation to the formation of OFCs and related matters. There are 6 divisions. Divisions 1 and 2 runs from rules 3 to 9, pages 3032 to 3044. It sets out the application for registration as well as incorporation, as well as the changes of name. Please continue. Part 3 is 10 to 14, running from 3044 to 48. That relates to capacity and powers of OFCs, as well as restrictions. Part 4, in relation to the Chinese version of Rule 12. Well, it says that there are various matters. Rule 12, it says any matter only. However, in Chinese, it says 事宜 and 事項, which are different. But in English, it says they are both 事宜, that relates to matters. But if you read the Chinese version, you would think that it is it's something different. I'll defer to the SFC because they are the SFC. They are formulated by the SFC.
Thank you, Legal Advisor, for the question. According to understanding, this drafting is, based on the company's ordinance that is Cap 120, and we don't believe that the drafting would give rise to any misunderstanding. My understanding is that of your question is that in Section 12 we use the Chinese terminology "si hong." The English version refers to the term matter. So you're saying why in the first case is translated as "si" and then is translated as "si hong." As I think the public would understand the use of the terminology in Section 12. We don't believe it will cause there's any risk that it will cause any confusion. I think you also use the Chinese word "goi," so there's no consistency here. But I don't think it's a big issue. All right. If there are no further questions, let's move on. Next, Division 4, which is Clause 13 to 15, is 304A to 3052, and this is about the instrument of incorporation of the OFC. This is to prevent people from using the structure of the OFC to engage in commercial activities. And instrument of incorporation, then it requires that it will stipulate the purpose of the company. Division 5, 16 to 18, 3056 to 56. This is about the communication and documents of OFCs and what need to be disclosed and requirements regarding the execution documents. Mr. Chow. A simple question, Chairman. Just now, the Secretary General or the Permanent Secretary said that the establishment of the incorporation is to ensure that it performs its functions. Now, for the M&A of the company, it should correspond to your requirements, right? I just want to confirm that. Director? Actually, the purpose of the OFC is to function as an investment fund. According to our rules, they will need to stipulate that the purpose of the setting up the OFC is that it should operate as a collective investment instrument. Well, my question is very simple, because every company has its own M&A. In the M&A, would the M&A correspond to your requirement? Would you require them to stipulate that in the M&A? Yes. In the rules, there is one requirement that the OFC should stipulate that the purpose of the OFC is to make a collective investment. So this is in Section 13. Any other questions, Mr. Chow? No. The MAA is called the Instrument of Incorporation, or 法團成立文書. It's not called 章程 in Chinese. Please carry on. Next, we come to Division 6, which is 19 to 20, pages 305A. This is about the Register Office of OFC, and when there's a need to change the address, the OFC would need to notify the registrar. Next, Part 3, Registrar's Functions and OFC Register. There are altogether 7 divisions. Division 1 runs from 21 to 23. It's page 3060 to 3064. And these sections are in respect of registrar may specify form, issue guidelines, and authenticate documents. Legal Advisor. I think members may note that under Section 22, registrar may issue guidelines. This is not a subsidiary legislation. Please move on. Divisions 2 to 5, that is from Section 24 to 43, 3064 to 3096. These sections are in respect of the registrar must keep records and maintain register of open-ended fund companies, and also the right to keep the index of names of these companies and to make them available for public inspection. And then 3096 and 3094 Division 3 include miscellaneous provisions, including the power of registrar to issue certificates. Any questions? Finally, Division 7. This is 46 to 55, 3010, 3018. This is to empower the registrar to conduct inquiry as to whether or not anyone has made a false declaration or statement. I think this is a drafting point, Section 55. If one look at the English version, 3117, 52 said the registrar must permit the person who is unfit. I think registrars may also impose other conditions. If you allow someone to do something, you must use the word must. But if you look at 3116 by 5, the Chinese version, is that the registrar or delegate may impose certain conditions, and then in Chinese it said 准許 or allow the documents to be checked. So here I think in Chinese the connotation is must. My reading of the Chinese rendition is that may. I think may not tally with the English. And then the government also agreed that there are two separate concepts here. Permit, they use the word must to check. 私家 is may. I'll ask the company registry to respond to that. Mrs. Ho, in our response, we've said that we need to read, when we read the whole section, we can see that the word may refers to the security or otherwise. So we think that the Chinese rendition is clear and would not give rise to any misunderstanding. I don't quite agree. If you look at the context here, the word may, is it may impose. Reading the Chinese version, I don't think you can highlight the difference, the conceptual difference. Could you substitute that? Don't strictly follow the. He said that the registrar may require certain person to do something and impose some conditions. Mrs. Ho? In 55 bracket 2, both the English and Chinese versions are actually based on the relevant provisions in the Company Ordinance 891 bracket 1. So we need to maintain consistency here. Any views from members? If not, let's move on. Next, we move on to Part 4. There are altogether, Part 4 is about share capital. There are 3 divisions. Divisions 1 and 2 runs from 56 to 62. Is 3120 to 3132. This is about the nature of shares and rights of OFCs, and also the transfer of shares. Any questions? Division 3, 67 to 72, page 3132 to 40. This is about register of shareholders of OFC. Questions? If not, Part 5, meetings and resolutions. 4 divisions. Divisions 1 and 2 runs from Section 73 to 83, 3142 to 3156. These provisions are about the convening of AGMs and notice of AGMs. Division 3, 84 to 95, 3156 to 370. This is about resolutions passed at meetings and procedure and matters relating to resolutions. 96 and 98, that would be Division 4. This is about records of resolutions and meetings. Questions? If not, move on. Part 6. Operators of OFC, including the directors, custodians, investment managers, and auditors. There are altogether 5 divisions. Division 1 runs from 99. It's 3178. It contains the definitions in part as used in Part 6. Division 2 to 5 runs from 100 to 147, 3178 to 3252. They contain the provisions regarding the appointment of directors, investment managers, and so on, including their appointment, their responsibilities, and their rights, and so on. Part 7, it's about the keeping of accounting records and so on. There are 3 parts. First of all, 148 to 150. This is 3254 to 3256. These are in respect of financial statements and financial reports. Questions? Division 2, 151 to 152, 3258 to 3260. These are in respect of financial statements and reports. The financial report would need to, honestly reflect the financial position and performance of the OFC and should comply with the relevant accounting standards. Super. Division 3. Please, super. Division 3, 153 to 157, 3260 to 3268. This is auditor's report and accounting records. Questions? Legal advisor. Thank you. Clause section 155. In the Chinese version, I think these are provisions in respect of certain offences. 1551 said that if someone, commits an offence, if he knowingly or recklessly causes a statement required to be contained in an auditor's report, under Rule 1542 and so on. If you look at the preceding sections, you have 2A, B, and 3. But here, it does not include 2A. Why? Thank you for the question. When we drafted sections 153 and 154, we want to model them according to the CO. 1.4, according to Company Ordinance 408(1), it does not include 407 bracket 2A. 1542A is similar to 407. The legislative intent is the same as 407, Section 407 of the Companies Ordinance. It's about, the auditor's report and any. So we've made reference of the CEO. We don't think that it's necessary to to make it a criminal offence, covering all the statements in the report, auditor's report.
咧就係
I would like to ask a bit more. That means under 2A, that is, the company has not kept adequate accounting record. Currently, the auditor may be penalized professionally, but it is not a criminal liability. Is that right? It is not a criminal offense. It is a disciplinary sanction. Well, you seem to have made it clear, however, but they are not reflected in the provision. Is that right? There is no need to do that? If it is not a criminal offense, then it won't be provided in the rules. The Hong Kong ICPA will have their own code and disciplinary procedures. Mr. Zhao, any questions? No? Please continue. Part 8 is 158 to 161. Page 327 to 72. They are related to sub-funds, including the segregation of legal liabilities amongst the different funds. Part 9 is 162 to 170. Page 3274 to 94. They are the arrangements or compromises of creditors or shareholders, as well as relevant provisions related to the CFI. Say, for example, power to call, AGMs, as well as recognition of certain powers. Is it the case that it's mirrored from the company's ordinance in relation to arrangements of creditors? That at least is the original intent, is that right?
Yes.
Yes. The majority mirrors the practice in the CO. Part 10 is in relation to receivers and managers, as well as their appointments. There are two divisions. The first one is 171 to 173, from 3296 to 3300, that in relations to matters related to appointment of receivers and managers. That is in relation to Part 6 of the company's winding up and miscellaneous provisions, Cap 3.2. Division 2 is 174 and 175 is 3300 to 3304. That is in relation to the notice of appointment and cessation of appointment and the requirement for them to be served on the registrar. Part 11 is in relation to voluntary winding up and dissolution. There are 5 divisions. The first one is 176 to 177. From 3306 to 3308, that is in relation to voluntary winding up of an SFC. That is related to Part 5 and of the company's winding up and miscellaneous provisions, as well as other provisions related to voluntary winding up. Division 2 is 178 to 187. From 3310 to 3316, that is in relation to under division alterations or modifications for the purpose of Division 1. The SFC has explained at the outset Let's say, for example, for the SFC, the registrar, creditors they can also petition. They can all petition for bankruptcy. They can also for winding up. Part 3 is 188. It's 3316 to 3318. That is in relation to winding up of sub-funds. So that sub-funds would be wound up like an OFC. Division 4 is 189 to 191. Is 3318 to 3320 in relation to miscellaneous provisions. Say, for example, if the liquidator calls an AGM, the liquidator has the duty to notify the SFC. Mr. Chow? Sorry, I have a question to ask. For Division 3, I think it's 188. That is in relation to sub-funds of the SFC and is winding up. Say it's a parent company and it's subsidiary. If there is winding up of the parent company, does it mean that the subsidiary will automatically be wound up, or they are separated, separate entities? Director, thank you. Under the OFC structure, we have set out a protected cell regime.
Protected cell.
So, subsidiaries under an umbrella OFC, there will be segregation of legal liability. The asset of the sub-fund cannot be used to pay the debt of another sub-fund of an umbrella OFC. So the sub-fund's asset can only be used to pay towards the debt of that sub-fund. Under an umbrella, say for example, there are a number of sub-funds. If there is one sub-fund that invests only in conservative funds, and another one that engages in a high leverage investment, we have this protected cell regime. If there is a sub-fund that is insolvent, you can't use the asset of the other sub-fund to pay the debt. This is not a new structure. There is this protected cell regime in overseas jurisdictions. In the principal legislation, we have already put in place this regime. What we need to do in the rule is to put the implied terms. That is, if there are agreements signed between the sub-fund and a third party, if the term contains that there won't be legal proceedings or other proceedings to obtain the asset of the sub-fund to pay towards debts not belonging to that sub-fund. Thank you. May I ask a bit more? Maybe I am wrong. I fully understand the concept. Say it's a mother and several sons. These two sons are of the same grade. I understand that then you can't use the asset of another sub-fund to pay your debt. But what if it's not of the same grade? What if it's the parent and the sub-fund? There is segregation. If there is winding up of a sub-fund, is only the sub-fund that is wound up. Nothing else will be affected. So the mother will not be affected. Well, please correct me if I'm wrong. If the parent company is wound up Well, the asset of the sub-fund is also the asset of the parent company. If there is winding up of the parent company, then the sub-funds will be affected as well. Say, for example, I have a company and my asset will be these sub-funds, and now the parent company is wound up. In a way, the operation of these sub-funds will be affected. So if there is winding up of the parent company, the sub-funds will they be affected by the winding up order? Let me clarify that for the umbrella fund and the sub-fund, it's kind of like parent and children. Well, there is the umbrella fund, under it there is segregation of sub-fund. At the umbrella level there is no asset. So is parent and the subsidiary. I thought that I control the subsidiary's the asset, but that is not right? If there is winding up of the sub-fund, you only wind up the sub-fund, nothing else will be affected. So if there are 10 sub-funds under one OFC, if I want to wind up the entire company, that means I have to go through the winding up procedures for 10 times. Thank you. There will be an option. Say, if it's just winding up of an individual sub-fund, that can be done under Section 188, under Rule 188. If the entire company, the entire OFC is wound up, that can also be done. This is only an additional option. There is no prohibition to wind up the entire company. Under 112S, in the principal legislation, it says that there will be a dissolution of the asset of individual sub-funds. If there is winding up of the entire umbrella company, it doesn't affect the segregation of sub-funds, but you can petition for winding up of the entire company. You talk about, say, sub-fund A asset cannot be used for sub-fund B. Well, if there is winding up for the 10 sub-funds, does it mean that there will be 10 liquidators? We don't require 10 liquidators. Well, it depends on the petitioner. If the petitioner wants only one liquidator, then the liquidator will have to look at the books of the sub-fund to petition for winding up. Well, the procedure will have to be specified. There is no requirement of different liquidators. But the liquidator will have 10 separate books or accounts, right? Mary? Well, I'll just answer from a practical level. An OFC and sub-funds, there is segregation of liability. So from the books, we can see the assets and liability of each sub-fund. So the liquidator will look at the books when dealing with the winding up. Mr. Chow, I have a follow-up question. Say, an OFC that is being wound up. There are two options. Say if there are 10 sub-funds, there is an option to wind up all 10 sub-funds, or there is an option to just select, say, 3 of the sub-funds. Is that right? I heard that you can choose to wind up all 10 sub-funds or just select some. Is that right? I don't want to be mixed up.
That would depend on whether what is interest, whether he's the shareholder or creditor when petitioning for winding up. Generally speaking, at the time of winding up, if we're talking about a creditor, he's a creditor to subfund A. Now, if he forcibly require the winding up of subfund A, B, C, D, since we have the segregation of legal liability among different subfunds, then this creditor would not be able to wind up subfund B, C, D, because the rule says that you cannot use the assets of B, C, D to pay the debts of subfund A.
Subfund or 3 or 10 subfunds of an OFC to be wound up as if they were a separate OFC. This doesn't mean that all the subfunds would have to be wound up. I think you were asking also whether if you had to wind up all 10 subfunds if you wanted to present a petition to wind up the OFC. The answer is no. You would not have to present 10 separate petitions. You could present a petition to wind up the OFC, in which case the OFC, including all its assets and all sub-funds, would be subject to the winding up procedures. I hope that's clarified matters.
Advisor, assuming all shareholders agree that all the companies be wound up, so there's only one option. Like Ms. He said, you would wind up all those funds at once and not separately, doing it 10 times, right?
The winding up of the OFC as a whole.
And you can't opt to do 10 separate winding ups for each sub-fund. You can't do that.
Well, I suppose you could, but I don't see why you would.
Which would only duplicate costs, right?
Yes, that's right, yes.
Okay, make that.
Yeah, understood. The Permanent Secretary already walked us through 188, 89 to 191. If there are no further questions, please carry on. Next, Division 5, which is 192 to 193, 3320. This is in respect of dissolution of open-ended fund company on cancellation registration. Any questions? Part 12, run from 194 to 196, 3322 to 3326. This is the miscellaneous part, including the offense for making a false statement and also the enforcement of court orders. Carry on. There is also a schedule to the rules. This is 3328 to 3332. The schedule stipulates the procedure regarding the regarding incorporation. So those are all the provisions under the rules. I think we finished the part 2 of the subsidiary legislation. Part 3 would be in respect of fees. Could the Permanent Secretary also walk us through that? Securities and futures open-ended fund companies fees regulation is in respect of the fees charged by the SFC and the provisions regarding the charging of fees. There are 3 parts and 3 schedules. Part 1, it's section 1 and 2, page 3364 to 66. And these provisions are in respect of the commencement of the rules and also the interpretation. The commencement day again is July 30th this year. Carry on. Part 2 is run from section 3 to 6, 3368 to 3370. These are in respect of fees payable to the Commission, fees chargeable to the OFC, and also provision regarding the payment of such fees. Carry on. Part 3, Sections 7 and 8, 372, fees payable to Registrar. And these are contained in Schedules 2 and 3. Carry on. Schedule 1 contains fees payable to the Commission. Part 1, there are 2 fees. That is, fees in respect of for application to register a company, and the other one is about, termination of. It's about the cancellation registration and so on. There is one question regarding the fees charged by the company registry. Do these proceeds of such fees go into the general revenue, or would it go to a trading fund? Company registry, it goes to the trading fund. So you'll be relying on the power vested on you under the 43430B. I also work on the anti-money laundering, ordinance. You need to amend 430B, but Section 7 is very broad. It's that any service, rendered pursuant to the company ordinance. Actually, it's based on the 2016 amendment to the SFO. It also amended 436D. If you go to Section 45, the consequential amendments, the 2016 amendment ordinance, 45B, sorry, 45, Section 45. We've added for a 4A, Section 4A. Okay, sorry. I don't have the backup yet. Please carry on, Madam Secretary. I think we've covered Schedule 1. According to Section 24 of the rules, the Common Registry would need to keep a register. And Schedule 2 stipulates the fees payable to registrar for inspecting or obtaining documents and information. Part 1 includes the interpretation of Schedule 2. Part 2 would be the details regarding the fees to be charged. There are altogether 6 fees. Schedule 3, other miscellaneous fees payable to the registrar, altogether there are 8 items. For example, lodging an incorporation form, and also incorporating an open-ended fund company, and also changing the name of the company, etc., and all the relevant fees payable. So those are all right. So I think we've finished the scrutiny of Schedule 3. Do members or our legal advisor have any further questions or comments? Then, according to the agreement, good to our agreement at the last meeting, I will move for a motion to adjourn the vetting period until the 11th of July this year. If we did that, then members and officials should note that if we extend the scrutiny period, then the deadline will be the 11th of July, and we will then report to the House on the 29th of June this year, and notice for moving CSA will be the 4th of July 2018. Right? Do members wish to bring up anything else? If not, we've finished the scrutiny of the 3 sets of subsidiary legislation, and I declare that the meeting is now adjourned. So thank you very much.